Yes, sir.
Yes, well, what I've done for your lordships is prepared a small, because I've been briefed on what was argued. So, I've prepared a note, so I just read that note, so it doesn't waste your lordship's time. I've given cross references, to both the judgments,
Yes,
as
sir.
well as the submissions. Just hand over, please, to my lord. Just the submission, just the submission. Give it to the other side, please.
Thank you.
I'll sit there. Some of the submissions that I made were not responded to, so I have put them up front.
Other copies? Only received one copy.
May I?
Yes, sir.
The heading is, the respondents have not responded to or dealt with the following points raised by the petitioner. One, the most important and proximate documentary evidence that in the speech made by the detainee on 24/9 from the Anshan site, in which he called off the Anshan with immediate effect and openly appealed for peace in Ladakhi and Hindi, which your lordships heard, which was available with the authorities, was not referred to or placed before the detaining authority. The detaining authority was thus not provided with the most relevant documentary evidence suggesting that there is no reason to believe, in the absence of the detention order, that the Detainees Act will result in the reasons for which the detention order has been passed. On the other hand, the detaining authority has relied upon an irrelevant video of 24/9/2025 recorded at 5 p.m. That is afterwards, after the violence had already erupted. This proposition I made at the outset not responded to, and I relied upon Ahmed Kutti, paragraphs 19, 25, and 27, which say that if a relevant document is not placed before the detaining authority, the detention is declared to be bad. I have prepared a separate compilation.
According to which is the relevant document?
The speech itself.
24/9/25.
That's the speech when he made an appeal in Ladakhi and Hindi that I'm breaking my anshan for the reason that you people have indulged in violence, but we are going the Gandhian way. That's the most proximate event that happened, because on 24th the speech is made and on 26th the detention order is passed. So what could be more proximate and relevant? That argument made, not responded to, and covered by Ahmed Kutti. We played it, my lord knows that. Then what is item 2? Well, if your lordships want, I can simultaneously quote the paragraphs in Ahmed Kutti because I have a separate compilation.
No, not required.
Not required, very good. Then 2 minutes. That the only 2 acts, this is again, I made a submission, attributed to the detainee were the Padyatra in September-October 24 and the incident of 24/9. Pertinently, in the Padyatra, no violent activity was attributed in respect of that protest and was in fact recognized as the most peaceful Padyatra by media channels. The other incident of 24/9, where the detainee, by his own actions, condemned violence. This is clear and evident from the record where he publicly stated that any form of violence was not acceptable to him. No other documentary evidence or speech had any consequence that led to the disturbance of public order. These facts have not been denied by the respondent. Again, Miller's not responding to. I made that, Miller's. 3. Many of the documents, including speeches relied upon by the detaining authority, are unrelated to the retinue. Many of the FIRs, Your Lordship knows, it's completely unrelated. My name is not there. 3 of the 5 FIRs that have been relied upon neither name the detinue nor contain specific allegations against him, have no relevance, and are entirely unrelated to the acts of the detinue. Additionally, out of the 8 videos relied upon in paragraph 4, this is important, of the detention order, 4 videos are more than 1 year old, and 2 videos dated 24/9/25 are from after the incident of violence that took place. Further, the detaining authority has in annexure B of the grounds of detention relied upon material having no nexus with any alleged activity of the detainee. The said material which pertains to the acts of third persons bearing no connection to the detinue and is not directed towards any conduct attributable to him. These videos, along with other material relied upon, are in the eyes of law stale and therefore cannot form the basis of an independent ground under Section 5A. No submissions have been addressed by the respondent in this regard. It is settled law that if the detaining authority considers unnecessary, immaterial, irrelevant circumstances, then such subjective satisfaction of the detaining authority would be vitiated and the detention order is liable to be set aside. But this is all in Paja Bilal. I've given the page number and the paragraph number. Nanabat Bujji versus Telangana. Again, paragraph number. Amina Begum. I've given the paragraph number 20 to 28 and 53. And Malada, I've given the paragraph 14 to 16. And just hand it over to my lord. We're just giving the compilation so that your lordships have simultaneously. And we've done it seriously.
This is in addition to the say authorities you have already relied upon.
Yes, yes.
Then in that event, we'll have to give an opportunity.
No. Your lordship will discard that. Whatever we have not cited, please discard it.
No. If you are citing, we are not saying don't cite it.
This
you are
is cited before. Before.
One second.
We put it together.
Yes.
Kalan Bila cited.
One second.
Yeah.
We just note down.
Yes.
See, authorities which you have relied upon.
Yes. Raja Bilal Ahmed relied upon. All this is relied.
You have relied upon. First one was Gurdeep Singh. Second one is Ahmed Kuti.
Ahmed Kuti relied upon. I've already shown you the first.
Third one is Sarbjit Singh Moka.
Yes. It's there.
Fourth one is Murtuza Hussain Chaudhry.
What happened is they made a proposition.
No, 1 second. So the fifth one is Jasila Shaji.
That's part of this already.
These are the 5 judgments you have relied upon.
Yes. Now, they relied upon certain judgments. Now I have to respond to that.
We are not saying we are not shitting out.
Yes.
What we are only saying is, if we are citing any additional citations, they will have a right of reply.
But the problem there is, problem is,
we are very clear on
that. Yes, the problem there is, if they have cited certain judgments for which, there is a proposition that is contrary to what they have said.
Show it. We'll look into it.
Yeah.
But to reply to that particular judgment which you are now relying upon, we'll give them an opportunity.
That will never.
Normally, reply is not permission.
But that never ends.
That is why. If you are giving anything new,
but how could I know what they were going to argue?
That's why.
I would never know what their proposition is.
Now, to demolish their case only by your arguments you want to do it, we will definitely consider it, Mr. Sibal. But if you want to rely upon any additional citation, they have a right of reply.
You also may give him a task.
Yeah.
I cannot say anything more than that.
Yes.
Okay. Let's
now, because it should not happen like this. In either way, suppose you are on the other side, other side were to argue and give 5 citations, and in reply they give 10. In further reply, you give 25 citations.
Well, then they will reply to this also by
Yes,
other
yeah.
citations, then
Yeah.
I'll have to answer.
Yes,
So how will they, where will it
that
be?
it's up to you.
Well,
It's up to you.
That
That is why.
well, they can file a written submission, brother. This can't possibly be that.
Only good judgments which are already cited. That can be done.
Yes, yes. If you are restricting it to citations already cited,
You can restrict to those if you want that already these are referred to earlier in that compilation. Like Faza Bilal is there, Ahmad Kutti is there, Murtaza is there. So these are already in your first compilation. If you restrict, it's your choice. Ultimately, as
we are not restricting.
it's ultimately your choice. Either you can restrict to all these which are already referred to.
No, why should she is not going to give us instructions on the law, right?
Mr. Sibal.
You are correct. He can't give.
It is quoted in our writ petition, brother.
These judgments in our writ petition.
We have put it in Padavilas all quoted.
Three or four already there.
Whatever you have quoted, whatever you have
Which
relied
one is
upon,
not?
we will
Baja
definitely-
Bilal there,
We just find out.
Jamila is there,
Bill is not.
Muhammad
Rest is all
Kutti is
there.
there.
All are there except Mohinder Singh Gill. I don't have to quote that one. Well, and give you the page numbers in the petition itself.
Mohinder Singh Gill that
Yes, because what's here?
supplementing.
Yes.
Supplanting the reasons.
Yes, yes. For that he can reply if he wants to. I have no problem. But all this is in our petition.
All right.
So it is, we haven't given them separate, but they are in the petition.
Your written submissions you have given. In that also you have cited many authorities.
No, it's all in the Khwaja Bilal, page 41. We didn't give you a separate judgment, but it's quoted there.
All right.
I'm just saying to your lordships that all the judgments that we relied upon are part of the, like Malada, for example, page 43.
Mr.
Amina
Sibal, I
Begum.
think we are not meant. If we have cited, we have referred,
Yes,
if we have pleaded,
yes,
no issue.
that's the issue.
Such-
So you also may take it further. There is nothing that we have cited here which is not clear.
In addition to that, if you are doing
That's where we tell your lordships. But this thing is the only one.
all.
And may I tell your lordships another thing? The reason why we have put this is that the respondents have not responded or dealt with the following points. This is in that category. We made that submission. They have not dealt with it. Now we are only giving your lordships the judgments which are already cited. Okay, Manu, so that's
Yes.
clear. Okay. Then 4. Additionally, the detaining authority has been supplied and has relied upon incorrect transcripts. This is a very, very important point. Again, not responded to. They have supplied and has relied upon incorrect transcripts of the videos, portions of which have been selectively extracted so as to mislead the detaining authority into arriving at its subjective satisfaction. A copy of the corrected transcripts have been submitted to the court by the petitioner on 29/1. The detention order is liable to be set aside also on the ground that the detaining authority has relied upon non-existing material. Since the transcripts of what transpired in the context of the speeches made by the detinue is not reflected on what is stated by the detinue. Therefore, the detaining authority is relied upon material which does not exist and has therefore arrived at subjective satisfaction based on non-existing material.
Like which one?
I gave you lordship the green and the red, remember?
Yes. We have got everything. Green,
Yes, now
red,
just
blue,
go to
violet,
that.
yellow,
Which-
all with Gayar. Everything is here.
Yes. Just my copy, I showed you your lordship straight up.
We'll show it to you. Transcript.
Yeah, you come this side, no?
Which one? Horizontal or vertical?
No, he's just giving you mothers.
This one? No, tell us.
This is the one, mothers.
What is it?
English transcription of relied upon videos.
Yes.
This one.
English transcription of videos relied upon
Yes.
detention order.
Yes, now.
Serial number 1 to 3.
Yes, now kindly come to page
Ah.
7 of this.
Page?
7 of this.
Yes.
Now
Seven,
kindly
eight.
come to the red portion.
They made in 3 colors: black, red,
Right.
green.
The red portion is what is in the relied upon by the detaining authority, placed before the detaining authority.
So,
But the green portion is what is said.
red is
If the central comes, see what the red says. Page 7, my lord justice.
what the Union of India is pleading.
Correct. If the
That is
and quoting.
that is referred to in detention order.
Yes, if this central government refuses to fulfill its promises and neglects the environment, I will dedicate my life to overthrow the present government. Some ask, how one person can change the government.
Sibal, these speeches is in English or in Hindi or
Ladakhi.
Ladakhi?
Ladakhi
Ladakhi.
translated, whereas the actual one is in green. If the government does not have affection for all its citizens, care for the environment, or violate the constitutional rights of indigenous population by not granting their rights, then such government is an obstacle for progress. This is what is the real speech. And what is what is relied upon is this. I've never heard of this in a detention order. Again, not replied to. And what's interesting is the learned Solicitor General, when he gave this note, didn't quote the red portion. He doesn't quote the red portion. He quotes the actual one. See his submissions, Malas. 8th June, Malas. Item number 5, 8th June, Malas.
Huh?
From the learned SG's Malas table.
This is the only speech, no? This is all something which is
That is not the same.
I hope I might make myself clear.
Absolutely.
What the learned SG gave to your lordships is correct.
No, now here are two competing speeches.
No, I rely on what the learned SG says himself.
All right. This is referred to by learned SG.
Yes, page 8th June speech, Malas.
One second.
Yes. In his chart.
Item number, that is serial number,
5.
that is 8/6/2025 YouTube.
Yes.
Huh?
Yes. Just find out, he quotes this. Find out where, if the central government refuses to fulfill its obligation and neglects, I will dedicate my life to overthrow the present government. No such thing. No such thing.
that green part is the true and correct translation of
Yes.
the Ladakhi speech,
Yes,
which
yes,
is
yes.
four
We
lines.
placed this. It was his duty to respond. We placed this before the court. I argued this before the court. If they had said, well, it was their duty to respond and say, no, this is not the correct translation. They don't address this at all. Instead, they give you a note, which note does not reflect what is stated in red here. So what is given to the detaining authority is a transcript of the speech which doesn't exist.
We want to know this entire speech is here
Yes,
of 8/6/95.
Yes, yes,
8/6/2025.
yes, yes, it's there.
From where to where?
I saw it.
Page
1
to 8
to 8,
of the transcript.
the transcript, 1 to 8 of this document that I just shown to your lordships. That's the entire speech.
Let us go to the. In the detention order,
Yes,
where is the speech referred to?
114, 13 minutes, 8th June,
1 second.
113 minutes, item 1,
Stated that
he
he
will dedicate his life, overthrow the election.
As shown in the inked time, slot 30:05 to 31:32.
Yeah.
Correct?
Yes. Now read this, Mullahs. India will not give statehood, then he will dedicate his life to overthrow the elected government. Where is that? It's not there. He also proposed self-immolation by Ladakhis. Where is that? Not there.
Mr. Solicitor, we want the actual transcript of these speeches.
I'll do. I'll please.
See, what he says is something different. What is found in your text is something different. What he is relying upon and asserting that this is the correct speech is something different.
You'll place it.
So
But whether we gave him a chance, but the point is,
you can be ad item on the issue of at least the text of the speech.
Right.
The interpretation, you may interpret something, he may interpret something, you may interpret something.
For the court ultimately.
We will decide.
well, my only request to your lords is not something that comes as a surprise to them.
That's right. We agree.
It is something that I have stated, I have argued. They have chosen not to respond. Now, as we get into the quagmire, they will start interpreting something in some fashion. This will never end, Mullahs. You give a chance to the other side, they have to respond. If they choose not to respond,
Because this is the basis on which the detention order is passed.
so I'm not saying no, Mullahs. I'm just saying that if I have put this in issue,
Correct.
Mullahs,
No, we are agreeing with you, sir. We are saying that I have already canvassed this argument.
yes,
I have put forth my contention,
Yeah.
and this was never rebutted to them by their reply.
right. Even in the table they have given, Mullahs, let's rely on their table, Mullahs. Where is this stated? Mullahs, why should we give them another chance is what I'm saying, Mullahs. Let's rely on what they've given to your lordships. The learned Solicitor General's, Mullahs, table.
Yes.
Where 0.5, where does it say overthrow the government? And this is not the only one.
40, 50.
India walks the path of lies and sells our mountains, air, and water to corporations, then protecting India becomes my sacred duty. I will say only this for now, that we all need to be prepared to save our mother Ladakh and mother India. Where is the question of overthrowing any elected government?
Mhm.
And it's not even reflected in the chart that they have given.
Next line also, you say that public mobilization and all that.
I'm sorry, my lord said something.
No, we are just reading that.
Yes,
We are just comparing this.
yes.
Even in your tabular column which you have given,
Yes.
this doesn't find a place at all.
Is it there? The tabular is a translated. The tabular column, whatever it has been furnished to submitted to this court is based upon the translation of his videos, nothing else. That is the.
No, that doesn't find a place in the detention order. If this is the basis on which you formed an opinion to order for detaining him,
Yes.
that should find a place in the detention
The
order.
detention order, multiple factors or multiple issues might have been weighed in his mind. Because sole issue alone is not the criteria to pass an order of detention. Multiple
But
issues.
there should be at least the correct transcript of what he states. You may have your reasons,
Yes.
assuming that you are supporting the order, saying that it was for the detaining authority to consider what way the speech was given, whether it had an impact or effect. But at least whatever stated in the speeches, we expect a true translation. There should not be a variance. Or it should not be even what he said is of a 2-3 minutes, and your translation goes on for 7 to 8 minutes, 10 minutes, whereas the speech is of 3 minutes. saying that I condemn this. Let us stop this. We have started this, but as the violence is there, I'll stop this. If that is only 3 minutes and your translation goes to 10 minutes, then there is certainly big variance in that.
No, not that translation is there any problem. No, ask who translated it. It's a proper translation. Well, I'll clarify. My instruction is that it is a department which has translated the complete word of the video. It was available. That has been done. That has been given to the court. As a
See these videos, they're in table. Where have
Well,
I-
for example,
no problem if an independent authority is to examine and give the translation by authentic Swami certified person also. Yeah, because we are not expert, we can't.
it's certainly the
Yes, the language is not known to me or anyone of
Not
us.
even to
Even
us.
Mr. Sibal also doesn't
Yeah.
know.
People must
Do you know Ladakhi?
no.
Nobody can.
From the kind of conversations I've had, I'd find out
No.
soon I will get to know it.
No, but now, see, we are in the era of AI.
Very dangerous.
Precision is 98.87%.
Very dangerous.
No.
I've tried the AI models.
No, at least for translation.
Assistance.
We
Assistance.
can get the
Okay, but
conversion.
let's go on to something else. Kindly
Yeah.
come to page 109.
The only message.
This is not the only one.
Oh.
There are several.
Yes.
Three last.
I'd like to see 109 free models.
So according to all these ratings, what is shown by the Union of India,
Yeah.
the green is the correct version.
Correct.
Oh.
Correct. And we put it on record and we've asked them that you respond to this. 109 C mother of the detention order. 109.
100?
Of the petition. Page 109.
109 is the
Of the
detention order.
Of the petition order. Which is the detention order.
Correct, we have got it. The grounds
See
are
item
given.
3. See item 3.
Yes. Start with Sri Sonam Wangchuk.
Yeah, exactly. Come to the last 4 lines. Notably, Wangchuk continued his strike despite MHA communicating the dates for meeting, which was his chief demand for sitting on a hunger strike. He also continued to provoke people, especially youth, by giving references of Nepal and instigating them to come out like Janji. Where is that? I showed you the speech itself.
And their own table. Where is
And their own table now.
this line come out?
Where is this line coming from?
Come out like
He's saying, stop the violence. I don't want any of this.
I don't know about Nepal. He's worried that he has not said anywhere.
So what I'm trying to say to you is, this is not the only case. This is one of the very unique detention order, where you rely on something which doesn't exist. And then you say it is your subjective satisfaction. Subjective satisfaction of something that doesn't exist. And this is now part of what the solicitor gave. There is no such thing.
Nobody has said come out.
Nowhere have I said that you come out like Gen Z. Nowhere. Again, 10.
10 September, we put 10 September.
See what it.
Is that for all the transcripts? Page number 3.
Now let's kindly come to page 13 of what I just gave to your lordships. Another piece.
One second.
Sorry.
Yes.
Let's kindly come now to page 13 of the document I just gave to your lordships.
Yes, 13. Today's.
Yes, not today's. The
Earlier.
transcript.
All.
This one.
Yeah, the transcript that I gave to your lordships.
Yes.
Kindly come to 13. Again in the red.
Red, blue, black. Oh, yes.
Now let's see. He while instigating the masses, again, he while instigating the masses, talked about bringing Ladakh to standstill by resorting to non-cooperation movement against the union government, UT government, pen down strike before government offices to make it non-functional. Right? Then he says, for example, from one angle, students' non-cooperation movement, government employees for cause of Ladakh's upcoming generations will not bow for today and tomorrow's salary and support the movement by pen down strike. Women Alliance will help to support the movement by telling these employees who are going to the office business by peaceful way, let them understand that it is not only for you and your salary and remuneration, it is for your upcoming generations. And what about our sons and daughters and upcoming generations? And make them realize by saying, aren't you ashamed of yourself by going door to door and help keep everything still? Then this kind of movement will be successful and peaceful on the guidance of Mahatma Gandhi and thereby bringing 10 lakh Ladakhis to a standstill by resorting to non-cooperation. This is what they relied upon. See what the translation is. To think of a situation where our demands are not met and our demands are sidelined, then can the entire Ladakh come together to demonstrate very peacefully and non-violently a non-cooperation movement as done by Mahatma Gandhi in the larger interest of the people of Ladakh and peacefully stop the functioning of government like a pen-down movement. In that moment, a person who has been on a hunger strike for the same cause will mean something, can make a change, and all eyes will be on each contribution made by the women, the youth, the religious, health employees, and merchants. How is this a reflection of what is stated here?
This is referable to that in which one?
No,
They have distinguished it better, they have written in the detention.
no, here they have not said.
Item 6.
Item 6, here they have only quoted what the detention order says. But I've found, I put all this in issue. Then kindly come to page 16. Kindly come with us. What other? Yeah, so two main things were there. Yes. By and large, these are the most important ones. There are others also. But let's skip over that. Now let's come back to my submission.
In a lighter vein, Mr. Sibal, you must have heard that couplet, हमने वो सुन लिया, उसने कहा ही नहीं.
और हमने कह दिया, उसने सुना ही नहीं.
That was just in a lighter vein.
I know that, नहीं, हम कह रहे हैं ना कि हमने कह दिया, उन्होंने सुना ही नहीं.
हम सुन रहे हैं ना.
इसीलिए तो हम यहाँ हैं. Now, let's kindly come to item 5 now. This is very important.
Item
5. I mean, it's page 3, Roman small 5. Of my submissions.
Yours.
Besides this, all the material relied upon by the detention order cannot be regarded as separate grounds of detention, which is the submission made by the detainee, as all of these are events leading up to the detaining authority allegedly arriving at a subjective satisfaction with reference to the events that took place on 24/9. Therefore, 5A cannot be of aid to the respondent in defending the order of detention. These are not separate incidents of acts of violence or series of acts which are separate and identifiable on the basis of which the detention order can be passed, but a cumulative impact of the materials available, resulting ultimately in the passing of the order of detention. And the SILA I had already relied upon. I've shown to your lordships. But I gave to your lordships an example of a person who smuggles every 2 months goods into India. Those are regarded as separate grounds because at the end of 1 year or 2 years, the detaining authority says, this guy is going to continue with these activities. Because if it were acts of violence committed every 3 months, 4 months, 5 months, in which Sonam Wangchuk was involved, you could have said that these are separate events. But there are no such thing. In fact, there is no act of violence. There is no issue of any disturbance of public order. In fact, when the public order is disturbed, he says, stop this. He is preventing violence. preventing disturbance of public order. Just the opposite. And that's why Justice Gawai's judgment, which I cited like last time to your Lordship.
Yes.
That's this judgment for the Jasila Singh, Shahji. Now come Millers to Romans small 6. It is submitted that in the facts and circumstances as set out in the detention order, the materials cannot be severed, since these represent materials pursuant to which the detention order is passed. Documents relied upon by the detained authority form the basis of the material, which form a chain of events which cannot be severed, and therefore the detention order cannot be sustained, and 5A does not apply. In fact, the judgment of the Supreme Court in Gautam Jain, have you cited this?
Relied upon by the other side.
Relied upon by the other side. Relied upon by the respondent to support the proposition of NSA, supports the argument of the petitioner, since none of the grounds are separate acts independent of each other, and that can be relied upon for the purposes of detention. That was the case of Coffee Posa, if I remember correctly, right? And there were separate incidents for us of violation of Hawala transactions, separate Hawala transactions. Your Lordship will find that in the judgment. I just showed that to your Lordship. But let's kindly come to the judgment, Justice Sikri's judgment. Page 49 of the learned ASG's compilation.
USG's compilation separate. There are two sets of compilations. Judgments.
This is the one starting with Pune Municipal Corporation, that compilation. That's with Pune Municipal Corporation.
It is.
One more is there.
First judgment, yes, this is the one.
Pune Municipal Corporation.
Correct. Now kindly come alert at page 49.
One
the
second.
judgment.
One second.
Small one?
Both of your Lordships have?
Yes, sir. Some small.
Yes.
Now see Miller's paragraph 3, so that you know the
Another
context.
three out.
Paragraph 3 of this at page 50 of this judgment, Justice Sikri's judgment, which the Gautam Jain, which the other side relied upon. Paragraph 3, page 50, Millers, at page 138, Millers, of the judgment. Otherwise, on top, your Lordship will find page 50. Judgment starts at 49. Lordship has it?
50.
Now,
Yes.
kindly come to 50. And sentence starting, the High Court has dismissed the writ petition. Right, Millers? Now it says, it may be commented at this stage itself that though the High Court has accepted the plea of the appellant that there was a failure on the part of the respondent to furnish certain documents, where one particular allegation in the detention order, it has been upheld, still upheld the detention order invoking the principle of section 5A. In a nutshell, the High Court has come to the conclusion that there were various grounds which formed the basis of the detention order, and even if the documents pertaining to one particular ground were not furnished, that ground could be ignored, applying the principle of segregation. Right, Millers? Now kindly come to paragraph 6. Paragraph 6, fourth line from the top, right-hand side, starting grounds of detention. Lordship has that?
Sikam?
Tacitum F.
Yes.
Right side, grounds of detention in support of the said order run into 46 pages, which enumerate various activities in which the appellant was indulging in making and receiving hawala payments upon the instruments received from abroad by him. And the appellant was making such hawala payments from his business premises at Chandni Chowk as well as residential premises at Shok Vihar. On receiving an information to this effect, searches were conducted, and what was found was 2 crores. So he was constantly indulging in hawala payments. That's why I gave you an example of smuggling. right, Mullahs? Now, this can be segregated because you have a tendency every time you are out, you make hawala payments. And in one particular case, you're not supplied the document. You say, fine, you have not supplied the document in one particular case, but the other detention order can still be upheld. This has no application to our case at all. And this fellow has been doing this since 2009, Mullahs. Yeah. For example, Mullahs, if I had been instigating the crowd, asking them to commit acts of violence, instigating them to do that, I did that in 2004, I did that in 2024, I did it in 2025, I did it again in 2025, again in 2026. Your Lordship can well say, look, you've been doing it in the past, these are separate, and these are the instances you've done it. Obviously, even in this case, if you're on one case, you've not done it, it's possible that you might do it again. But there is no act. This is a case where I have never instigated anybody to commit acts of violence. It's just the contrary. And the most proximate speech to the detention order to the 24th, which they don't look at and they don't supply to the detaining authority.
Suppose by your repeated speeches,
Yes.
maybe in this or in some other,
I-
you just want to know
Yes.
from your side.
Yes.
Suppose initially he makes a pitch,
Yes.
then escalates,
Right.
keeps on escalating,
Right.
thereby creating a tempo,
Yes.
and then ultimately boils down to that.
Right.
Can it not be said it is separate incidents?
Well, it will all depend on what kind of speeches he makes. It all depends on that.
It can,
No.
but it all depends on facts of each case.
No, what kind of speeches he makes? First of all, you have to come to a factual conclusion
Correct.
that he instigated
This linking with that.
Yeah.
that
Then you have to
linking
say
with
on this date, you're further instigating the crowd. Correct, Manas? Right? But then on the last date, you tell them, stop this. Then how would it be, how the detention order be upheld, Manas?
No,
If that's the case.
What we are thinking is whether this can be put in a straitjacket formula.
Manas,
It can't be.
No matter in court can never be put in a straitjacket formula. Unless, Manas, your lordship decides the principle of law. Then, of course, it has to be. But ultimately, whether it's bail or it's acquittal or conviction, it will all depend on the facts of the case, Maharaj. And that will apply to a detention order as well. Your lordships will have to see the mindset and see what the attitude of the person is, right? And in the grievances, there was a promise made to us in the manifesto. And now 5 years have passed. The promise has not been fulfilled. We must do something about it. That's all. And what is that? What is the option that is chosen? The option is of answer, right? Not option of violence. Not option of self-innovation. Yeah, that's it.
Independently choosing them.
Right from 2022, 2023, 2024, 2025, has any speech of his resulted in any act of violence? I told your lordship, 2 acts only. Padayatra, those are the acts. And this. So on a proposition of law that your lordship is putting me, but depending on those facts, your lordship may come to a different conclusion. We are not casing with, not dealing with the case of instigating anybody for committing acts of violence or even public disorder. So you can't apply a coffee posa principle of hawala or of smuggling and say that, look, apply that principle here. That's all that I was trying to say, distinguishing the judgment. Yeah. It's done. Then let us kindly come to page 4, item small 1I. Governor, I demonstrate your lordship is a complete copy paste. My learned friend make a very sort of impassioned plea that he's applied his mind in those 4 paragraphs, but they are not a copy paste. Now, luckily we've got just give it to my lord. In fact, he handed it over to your lordship, I thought.
Which one?
The 4 paragraphs he said, which are application of mind and not a copy paste. If your lordship will remember.
No, that he had given only 2 pages.
But I've got all the
But we got the remaining page.
pages.
Of course, we have got the original record.
Yes, but the original record will show what we are showing you. Yes. They just changed the number of the paragraph, that's all. Now, let us take this and juxtapose this with page 116, Madam.
Which one?
Juxtapose what I have given to your lordships at page 6.1, paragraph 6.1, with Mother's page 116 of the petition, which is part of the detention order.
That 6.1, I am satisfied.
Yes, I am satisfied. Now, see, Mother's, kindly see para 5 of the detention order. Just let's read it. Page 116 of the writ petition, which quotes the detention order. So you know why it's a copy paste. That's why I'm asking your lordships to look at that. 5 to 9, according to them, was independent application of mind. This is what they said. Now kindly look at 5. I'll read it. It's from the detention order first. Sonam Wangchuk is actively abetting, instigating, promoting, motivating, and conspiring with his supporters subversive activities, endangering sovereignty and integrity of India on grounds as mentioned above, and as such is acting in a manner prejudicial to the maintenance of public order. Further, these activities are also very likely to disrupt essentials of person. Now read 6.1. I am satisfied that the proposed definition actively abetting, instigating, promoting, motivating, and conspiring with his supporters subversive, exactly the same words, endangering sovereignty and integrity of India on grounds as mentioned above, and as such is acting in a manner prejudicial to the maintenance of public order. Further, these activities are also likely to disrupt essential services. In this context of the aforementioned facts, the reference may kindly be made to the following. Right? There's just complete copy paste. Exact words are copied. Now, let's kindly come to the next one. That is paragraph 7 here. And read paragraphs 6 and 7. Let's read 6 and 7 months of the page 116. Well, let's kindly have a look at 6 and 7. I'll read it from 116. With reference to the above aforesaid provisions of the NSA, Wangchuk has to be detained so as to obviate the possibility of committing any further acts which are most likely to have an adverse effect upon not only the maintenance of public order, but are also most likely to jeopardize the security of the Union territory and the sovereignty of the country. Particularly, Sonam Wangchuk, if he is not preventively detained, was most likely to repeat his acts which have bearing on national security and public order. Sonam Wangchuk has created a serious situation in the UT by inter alia misleading the public in the name of statehood and 6th schedule, and by exhorting his supporters to resort to violent protests and culminated in loss of life and property. In lay, the gravity of the said apprehension gets compounded by the fact that the proposed detainee has maliciously and regularly fanned anti-government sentiments and exhorted the public to act against the interests of the government of India. Now read, Mothers, paragraph 7 and 8 of the recommendations. With reference to the aforesaid provisions of the National Security Act, I do hereby submit this present report to you, which is a proposal to appropriately recommend to the UT administration that the proposed detainee should be considered to be preventively detained so as to obviate, exact words, obviate any possibility of the proposed detainee committing any further acts which are all most likely to have an adverse impact upon not only the maintenance of public order, but also likely to jeopardize, the exact words, the security of the union territory and the sovereignty of the country. Exact words. Particularly the understandings of the opinions of the close detinue, if not preventively detained, is most likely to repeat these acts which have bearing on national security. The exact words are repeated. Thus, it is most humbly submitted that if the post detinue is not preventively detained, he has created a serious situation in UT by intelligently misleading the public the same words in the name of statehood and sixth schedule, same words, and by exhorting his supporters to resort to violent protests and culminating in loss of life and property in death. You may kindly appreciate the gravity of the said effort gets compounded by the fact that the post has maliciously and regularly framed and exactly the same words. Well, how could anybody even argue this? That this is application of mine and these paragraphs are different models. They know the facts. We didn't know the facts. They know the facts. It's lucky, Malad, that we got this document from the detinue. But they should have placed the correct facts before your lordships. That's not fair. Now see paragraph 8, Malad, of page 160. It is essential that peace, law and order prevails in the sensitive border areas of UT or Ladakh. Wangchuk has deliberately strained the peaceful atmosphere of the UT by inciting the public at large to indulge in acts inimical to public order and national security. He indulges in fear-mongering, alleging absence of democracy in Ladakh, takeover of Ladakh by outsiders, snatching of land by the public, and denial of rights of the public under the administration of UT government. Further, he has been promoting public against development projects in Ladakh. Same, read this, mothers. You may kindly appreciate that it is essential that peace law, once peace, law, and order prevails in the sensitive area, same thing. Proposed detinue has deliberately strained the peaceful atmosphere of UT by inciting public at large to indulge in acts inimical to public order. He indulges in fear-mongering, exactly the same words: absence of democracy, takeover of Ladakh by outsiders, snatching of land from the public, and denial of rights. Further, he has been promoting public against development projects. Is it fair, mothers? Is it fair? And even the conclusion on account, see the conclusion starts with the sentence on account of this above activities. The same conclusion. So if this is how a government officer, mother, applies his mind, then God save our country.
Yes.
So, mother, that's the copy-paste argument that I've dealt with now. Fully covered by your lordship's judgment. Yes. I can stop now if you want. Then they refer to some green sheet, mothers. We've not got any, we have no idea of any green sheet. We've not been supplied any green sheet. This is why Mahinder Singh Gill comes in, mother. Huh? I know none of this is in the pleadings. That's why I said Mahinder Singh Gill is the only judgment. That's in small Roman 2, page 4, Mulad, of my submissions, item 1.
On 1 second, Mr. Lee.
Sorry. sorry.
Yes.
Now, let us kindly come to page 4. Well, I have a small request to make, Malas. Your lordship will give me another 15-20 minutes, maximum half an hour. I can finish it today.
Today.
Yes, your lordship don't mind. The result is if I can't, because there's a
Wait.
election petition partner tomorrow in another court, I have to be there, Malas. And this will then otherwise not finish. It's my small request if it's possible. If not, Malas, then
We have some other commitment at 4:15.
I see. All right.
Tomorrow, what time you are engaged there?
Well, there's the MK Stalin's election petition.
What time?
Morning. It's a partner matter, special bench.
All right, you finish that and come here at
That
3
won't
o'clock.
finish. That won't finish.
Oh,
It won't. It's fixed for 2 days. It won't finish. Let me try and finish by 4:15 if it's possible.
all right, you
Let me try.
4 till 4:10 we'll sit.
I'll do whatever I can.
No, no hurry. Even we can see that as far as possible, both these sides will see that they are extended full opportunity.
The lordships have been very kind. And in any case, both of us have had the opportunity. There's no issue at all.
Only last Friday we had to, because
Yeah, I understand. No,
brother was not, I was also not there, you know.
Yeah. I would have. Anyway, but let me continue for a while at least.
Oh.
Then kindly come to page 4, item small 1I.
Item?
So page 4, item small 2, small 1I. That's the green.
There's no page number.
No, in my submissions, but in my submissions.
No.
My submissions.
No pagination
Oh,
to.
it's no page number is there.
It's injustice.
Only my brother has got the pagination.
Oh, see, this is discrimination of the highest order.
Probably this is your copy, sir.
No,
This is second copy.
Paragraph is there, no? You can
All
read
right.
the paragraph.
A paragraph Roman 2, Malas, 1.
2.
2-1, all right.
So this is, Malas, in respect of that. I'll just skip it. This is in respect of that to copy paste.
That you made that.
And the green sheet. The
Verbatim.
respondent further argues that the green sheet has been provided to this honorable court. It can't be done with us. As part of the original supply, which reflects the independent application. What does this mean? File notings and all that. I mean, how can that be? Never supplied. I have no idea what it is. And in any case, all they can't go beyond the counter affidavit. Your lordship has said it in several judgments.
Same.
If they rely upon the green sheet, it has to be supplied to me.
Probably it was matching to your green marking. So learned AG also said I should also bring some green
Very well.
color to this.
I just skipped this, Malas, quickly. Now kindly come to 2. Then Murtada Hussain Chowdhury versus State of Nagaland. Squarely applied to the present case is the approval of preventive detention, but it was evidently not arrived at after independent application of mine. In the present case, it is evident the detaining authority has merely reproduced the grounds of detention prepared by the detaining authority, thereby demonstrating complete non-application of mind. This BCS the very basis of the order. Well, their only argument was 5 to 9 of the paragraphs 5 to 9 are an independent application of mind by the detaining authority, which I have demonstrated to your lordship is not. It's a complete copy-paste. Now, this is another argument. But your lordship knows that there are two rights available to a detainee. One is the right to go before the advisory board. Whereas when the advisory board renders its opinion, then it goes to the state government. And the state government confirms it. Right, Mulas? Now, I have a right to make a representation both to the advisory board as well as to the state government. That is settled law. Now, Mulas, the documents that were given to me were only on the 5th of October. The laptop was given to me only on the 5th of October. So much the time was, I could not have, by that time, the state order is 4th October. The state order in this case, confirming, is 4th October. And I get the laptop on the 5th of October. So my right to represent before the state government, because I have two rights, is violated per se. And we didn't know this till my learned friend supplied to me.
State government order is 5th.
4th October. Maharaj. We only got to know this when my learned friend gave this document to us in their convenience compilation. We had no idea.
Came to know
about the fact that on 4th October, the state government had confirmed the order. This is at page 49, Maharaj, of their convenience compilation. Yes. And two constitution benches confirmed this law. This is the order on 4th October.
Your right to file objection to the detention order, you were supplied on 29/9.
But the video I got only on the 5th of May, Maharaj. The laptop, Maharaj, they gave me the pen drive as I told your lordships. The laptop was given to me on the 5th of October.
When you got it on 20s, you supplied the detention order on what date? 26/9 or 29/9?
29.
29. Did you say that these links are not being given to me, or I was not shown, I was not looked into, or I do not know the contents of those links which has been referred to?
No, I showed you on page 100 and...
Because if you remember, I think solicitor or additional solicitor made a submission that it was shown to him, and after having seen only, he received it and accepted and signed it.
Well, where does he say it in the counter affidavit?
Mention.
Nowhere.
No.
Nowhere. This is an oral argument, which is again Mahendra Singh Gill.
Page 3. This is the investment. Never says not filed in the court.
There's this there. Now, they see there, compilation page 3, which is one. So says, I have received the document as per the above index numbering 41 pages and a pen drive of 29th August. It says,
National Security Act.
confirmation of the order is in section 12 of the NSA Act, Mullah. And reference to the advisory board is section 10, and procedure before the advisory board is section 11. And my right is under 8(1).
Murtuza case was under the which provision?
Psychotropic substances, Mullah.
NDPS. So whether this
It is para-material, Mullah. It is para-material. It's para-material. But Maharaj, I'll take Maharaj on a demurrer, I'll accept the fact. Let's assume that he is right, that they showed it to me. I'll assume it for the hour. That's not enough under 22.5. Showing a document is not enough. What is the document? My speech. Those 4 videos. Showing is of no use to me. You have to give me the document. 1, showing is not part of counter. 2, even if you accept the fact that they showed it, it's still violation of 22.5. He does not say that the laptop was given to me. He says that the DIG, whoever he was, sat with me and showed me. Let's assume he's right. Not part of the counter, but let's assume. It's still violation of 22.5. You have to supply the document. Supposing somebody says, I showed you the grounds of detention. Is that enough? I mean, sorry. Well, as Ahmed Kuti says, and I won't trouble you a lot, it says to appreciate this point, one has to bear in mind that the detainee is in jail and has no access to his own documents. It is reiterated that it being a constitutional imperative for the detaining authority to give the documents relied upon and refer to in the order of detention, pari passu the grounds of detention. Those should be furnished to the earliest, at the earliest to the detainee who could make a effective representation. Question of demanding documents was wholly irrelevant. Your Lordship put it to me. Did you demand it? What the court says, that's not
No, because on the other day, Mr. Tanka made a submission that it was not even shown to us.
It wasn't. It wasn't. It's right.
At that time, the ASG rebutted saying that it was shown to him.
Manas, he can't say that because it's not part of the counter. It is not part of the counter, Manas. This is an oral argument being made by him. Manas, what he showed to me were other videos. Manas, this pen drive has, I've got the pen drive in there, and I can give it to you. Manas, if anybody modifies that pen drive, it will be shown. That pen drive has videos. Not these 4 videos.
Each of those, we have 2 pen drives. 2 pen drives.
Ask them to give you the pen drive. You will see the 4 videos I have.
This is the one given, you have also given 1 pen drive.
We'll give you the pen drive. We have it.
No, you have already given. She has given it to us.
No.
The pen drive that we received from them, we have not given to you. That is the one that the petitioner has received, which does not have those 4 videos.
Malal, the pen drive we have,
This is
as your
one
Lordship
not
knows, that
from
in a
this-
computer there is a hashtag number. If you try and modify the pen drive, it will show we have the pen drive,
Sure.
and the 4 videos are not there.
This was received by us.
This was received by us. This was received by us. So we stick to our position that it was not
This
shown.
is the copied pen drive.
No.
The one which was furnished to you,
It's the original pen drive.
original pen drive.
Original
So
pen drive.
you don't have that pen drive.
I have it.
Your Lordship, this is the original pen drive that has been given to the petitioner.
And in the jail.
No, what about the detainee? Detainee was not given.
The same one that was given to the petitioner was given to the detainee, Your Lordship. That is our case.
So the detainee is having 1 pen drive.
Yes, Your Lordship. Without our case is that the first time he got laptop access was 5th October.
The detainee does not have the pen drive, which is, it is the same pen drive which the detainee is also having.
Yes.
That's what he
Yes.
said. They have 2 pen drives.
See, now, 1 pen drive which is given to us today
Petitioner.
is the one which was given to the petitioner.
Yeah.
And the same pen drive was
Is
given to
with
the detainee also.
That's
Right?
Yes.
And it doesn't comprise of the 4 videos.
It will not have the 4 videos. Well, so our argument is three levels. 1, never shown to us. only the links were given. 2, not shown to us, the computer.
We'll ask your client,
Yes.
Sibal,
Yeah.
to hand over
Yes.
that pen drive
Yes.
by the detainee, which is available with him in the jail,
Yes, sure. Sure.
to your officers.
Please.
And we want that pen drive. Let it be sealed in his presence.
Yes.
All right? Let it be sealed in his presence in a small box or whatever.
Very
it
good.
Provide it.
You can see it. No,
And
yes.
as is varies, tomorrow itself you ask him to,
No,
it will be in his custody.
Yes.
Obviously, it will be in his custody. So let him.
There's just a small, your lordship, we were supplied then those 4 videos on 23rd October by the advisory board. So there may be a separate, there may be 2 pen drives because we do say we got it 28 days after. So it should be
You
mentioned.
would have definitely have had
You
pen drives.
supply the original pen drive.
Yes, of 29th
Of
September.
29th of September.
29/9/2025,
Yes,
the one which was supplied by
Yes,
the DPI,
Yes, that's the one.
which is said to have been shown,
Said to have been
Yes,
said to have been shown.
Yes, Your Lord.
You ask your detainee to see that it is kept in a sealed box and hand it over to your officials.
Correct.
And your officials, then let them hand it over to us.
Sure.
Yes, no
All right.
problem. No problem.
You want an order?
We can bring it to you, Maharaj.
No,
You don't have to. Why? It will show if nobody has modified.
no.
Okay, fine.
We never use the word modified. You are saying.
No, I said nobody can modify it.
We know that.
Yes.
We know that. That is-
Therefore, better as
I have no problem.
hand it over to the
Let it be
Officer.
sealed by the detainee himself or in the presence of the detainee, let it be put it in a sealed box
Yes,
and forward it. Give it to us.
fine. No
All
problem.
right?
No problem.
You can.
And in any case, it won't be there because they're not there. He couldn't have shown they're not there.
let us at
But you have a look. You have a look. So therefore, the argument is threefold. 1, it was not there. 2, it couldn't have been shown. 3, even if it was shown, it doesn't matter because you have to give the document to us. So in either case, Maharaj, it will. Maharaj, may I then request this, Maharaj, because this won't finish today. Then, Maharaj, your lordships may put it on Thursday.
Friday, it's not possible. You are making.
To try and put it on Thursday at 2, Maharaj, I'll see if I can finish other matters. If I have a problem, I'll tell your lordships. Maharaj, what happened was because of my illness, all the matters got adjourned to those days, Maharaj. Even the part-heard matters. So that's the problem.
It's majorly almost.
All right.
Majorly.
Kapil Sibal, Aravind Senior Counsel appearing for the petition. For further arguments,
Yeah.
they are Thursday. Thursday, 2 p.m.
Still you want to order?
Where is the other one? They first.
My lord.
Maharaj, your lordships may pass the order about the sealing, Maharaj.
Yes, that will be better.
Better.
The learned senior counsel appearing for the petitioner will submit that the pen drive furnished to the detainee
29.
on 29/9/2025 is in his custody. Stop. As such, we direct that the said pen drive in custody of the detainee shall be obtained from the detainee by the jail authorities in a sealed box, which shall be sealed in his presence and be forwarded to this court in a sealed box by the superintendent of jail. Where is the jail?
Rajasthan Council is also.
Rajasthan. And the standing counsel appearing for the state of Rajasthan,
Additional Advocate General is here.
the additional advocate general appearing for the state of Rajasthan shall ensure compliance of the same, of the compliance of this order by day after tomorrow. I think it can be brought by a special messenger.
Please, we'll do it. Nice.
Oh.
Thank you.
Let's may I please request for item 51.
Let us,
Yeah.
one second, let us organize our papers.
I'm sorry.
May I be excused?
Yes, yes. Otherwise it will go haywire.
Sorry.
Make your one and do it.